Good morning.
Miss Pugh.
I appear on behalf of the appellant.
Thank you.
Scott appears on behalf of the respondent. This being an extant appeal, there have been several moving parts until recently.
Yep.
So if I may just go through some preliminary points so the court appreciates where we are. Firstly, you should have received a medical report
Yes.
from a psychiatrist.
From the consultant forensic psychiatrist.
Yes.
Yeah.
We don't have permission to rely upon that.
No.
My learned friend has suggested that you consider it to Ben essay.
Yeah.
And make a ruling at the end, and I am in agreement with that course of action. It has lost its some of its relevance in any event.
Well, because we've seen your further letter yesterday. Yeah. I'm
grateful. Thank you. That takes me to the second point, which is the scope of the appeal. That has narrowed. We are not pursuing ground 2. We also are not appealing the finding of contempt. We might disagree with the reasons, but we'll deal with those when it comes to action. We admit the contempt. Again, I, on behalf of my client, Mr. Darby, apologise to the court that he was so late and for the contempt itself. In practice, therefore, today is about the appropriate sanction for Mr. Darby. Thirdly, my third point was the apology.
Yeah.
And my fourth point was there's also an extension of time application. This appeal was made significantly out of time.
Yeah.
The reasons for that are in the application notice, petition to appeal. Given time constraints, I was not going to spend too much time on that at this stage, but I might respond if my learned friend wants to oppose that application.
That seems sensible. Yeah.
Thank you. And then timing, my learned friend has graciously agreed to limit himself to 45 minutes, 50 minutes. So I will take up the best part of an hour.
Can I just check? So the ground of appeal that is being pursued relates to which ground? It's just ground 1.
1, 3, 4, 5. You say the medical report is relevant to personal mitigation. I can take you through that now, if that's convenient.
Can I just check before we get into the detail of the grounds of appeal and the response to it? The sentence imposed on your client was 18 months in total, of which the judge provisionally, not binding anyone coming afterwards, said 12 months was for purging and 6 months was for punishment for not being honest in the first place. What's the position now? That is it common ground there has been a purging of the contempt or any of that aspect of it?
My lord, it's not common ground. There's been purging of contempt, but the more fundamental point at this stage is we say this isn't really the forum for that to be considered, because if it is said that there has been a purging of contempt, the proper course is to make an on-notice application under CPR 81.10. And in response to that application, of course, my client would have the ability to put in evidence which one would assume may include a further expert report scrutinising the blockchain. So we say that's the proper forum for considering whether contempt has been purged, and it's very
as to whether or not what he said, that he does have the ownership of these 100 Bitcoin.
Yes, and in short, we say it should go further than that, because the contempt is not giving in short, it's a little bit more complicated than this, but in short, basically, it's not giving truthful asset disclosure. Now, saying that in fact he owns these particular assets is not necessarily the full extent of truthful asset disclosure, which is in
I
fact,
appreciate that, but that might be a separate contempt. That's not the contempt that was proved against him. That's why I asked you about this contempt. You can, of course, if he still is minded to mess around, and there has been messing around, apply to commit him for contempt because he fails to turn up on an oral examination and fails to answer questions about that. But that's a separate contempt. The contempts that have been proved at the moment, he has admitted, and he said sorry for. Anyway, that's fine if you all want to spend a great deal more money on very long proceedings, but you would have to be very well aware that what he proved is not that he might have lied in other mistakes. I well understand why, given the history, you might have that suspicion, but that's not purging this contempt. If, on the other hand, you're all prepared to sort out this contempt, you can then go away and fight each other till kingdom come, although experience shows that rarely helps everyone. That's fine, but we're dealing with this contempt, which are 3 contempts, which provisionally he seems to have accepted and have dealt with. But anyway, if you all want it referred to first instance, or you want it referred to first instance with all the consequences that come with that, that's fine.
my lord, if I may come back on that very briefly.
Of course.
I suppose the point is not so much that we say that's what we actively want and it's an inevitability. It's that this today is an appeal regarding what happened below. So it's not the forum.
I appreciate that, but when we're dealing with contempt and purging contempt, it's obviously relevant to take into account issues of what has developed. Contempt and sentences are one where fresh evidence will be looked at in a way that sometimes it's not looked at on other appeals for understandable reasons. Anyway,
yes, my lord.
Good. Okay, thank you very much.
My lord, just to come back briefly on that, I would say that your powers under Section 13 of the Administration of Justice Act are broad enough to take that into account if you are imposing a correct. If you are with me on the grounds of appeal and are considering which.
Well, if we're with you on the grounds of appeal, we then have to re-sentence.
Yes.
Yeah.
And you can take that into account.
Yeah. Thank you.
Thank you. So I will move to ground 1 of the appeal, if I may. This is the most substantial ground that I'm pursuing, and it's a fundamental one about the right to legal representation and the right to be informed and have a reasonable opportunity of applying for and obtaining that legal representation on an ongoing basis. Contempt, of course, being non-means tested, and I say that's relevant. You have an authorities bundle. I apologise again that it is suboptimal. And
don't worry. We understand the time pressures that both sides have been under, and we're very grateful for all that's been done.
Well, I'm extremely grateful, my lord, for that concession. In tab 1, there is Article 6.3, and we're dealing with 2 minimum rights. I won't take you to it in the assumption that you have it well in mind, but it is there. The minimum rights are set out in 6.3.
Well, which ones do you say weren't complied with?
Well, yeah. So tab 1, internal page 10.
Yeah.
3C is to defend himself in person or through legal assistance of his own choosing, or if he has not sufficient means to pay for legal assistance, to be given it free when the interests of justice so require. But
so,
also,
I mean, the evidence strongly suggests he did have the means to pay for it.
yes.
So, what's your case on breach now that we know what we know?
well, we also rely on B to have adequate time.
Right,
of
hang on,
sentence.
let's go back to B then. So are you still relying on C? Is that all right?
Yes, we are.
And what, can you just particularise your case on C before we leave that?
Yes. So C is legal assistance. He's got a right to legal assistance of his own choosing. Now, it is entirely correct that the appellant did not engage at all with the contempt proceedings right up until the contempt findings were passed in his absence. However, after that, in the space of really the last week, when the threat of the warrant came to his notice, he did a complete about-turn and not only engaged, but attempted to comply with all the recommendations of the judge. So he attempted to get legal representation, and it is that that we say means that there's still a breach to Article 6, and it's in that context that you should be looking at the period between
12th of June and the 24th of June.
yes, or even narrower from the 17th, which is when he first engaged, until the 24th. Now, I am not suggesting that all contemners should be given unlimited attempts or opportunities. I'm saying in the context of this case, with such a short period from when he started to engage, he was entitled to a reasonable opportunity at that point. If one thinks about the way these contempt proceedings occur, there is inevitably a gap between findings of contempt and actual sanction. And as the judge in this case made plain, that was so that the issues at the sanction hearing can be separately addressed. And it's also because it is not uncommon for a defendant to fail to engage with the contempt proceedings until findings are made. And then when the threat of imprisonment is really there, to realise the seriousness of the situation and to wish to participate at that point. Now, if one considers that the reasonable opportunity has already passed by that date, he didn't engage prior to the contempt findings being made, then there's absolutely no point in there being an adjournment for the sanction hearing. Given the premise and the practice of the courts to delay to provide time for the sanction hearing to be provided for, the question is whether there is a breach of his rights in this case because he wanted legal representation and he was not granted it. If I may take you sorry, I'm just checking. If I may take you to the some of the case law.
Yep.
If one looks at Reed and King, so this is at tab 5 of the authorities bundle. And
King and Reed.
yes, King and Reed and Slack.
Yeah.
And it's internal page 429. And one sees towards the bottom, 2/3 down, there's a paragraph beginning the next matter. And then about halfway through that, a sentence. The appellant is undoubtedly extremely truculent. He made it clear he did not want any help. His view was that he had not done anything wrong and that he did not need witness or representation. The attitude of the appellant in general was to object vehemently to any action by the court which was designed to extract him from the money which he contended was due. Then over the page to 430, and then about a third down, it says putting it at its lowest. If you're there.
Yep.
The appellant should have been informed by the district judge, sure would have been if the district judge had been aware of section 29 of his entitlement to legal aid. If he had known that this was a situation where he could get free advice, then his attitude to representation might have been very different. And then a paragraph below, in addition, as was pointed out by my lords in the course of argument, the truculent persons such as the appellant will often benefit from legal advice over and above the benefit which is normally obtained, because it would include advice as to the inappropriateness of the conduct with which he was involved. So my point there, really, it answers my lord's point about the fact he could afford to pay.
Well, that was specifically to the wording of Article 6.3c, which is... anyway, it doesn't matter, yeah. Because this is common law. You started off with the European Convention of Human Rights, which is, of course, entirely up to you, but you might have thought that the common law was stronger in this respect than the Convention.
Yes, well, I say there's no material difference between them both once we go through. The point that my learned friends make about Rule 81.4 under the new Rule 81, I say is only relevant to the conduct of the respondent and the duty on them to draw the attention of the appellant to his rights. It is not relevant to the court's duty and the onus on the court, which goes well beyond simply a sentence in the contempt application notice.
So this is really your ground 1D, I think, Ms. Pugh. I think, is that the focus of your essentially challenging what the judge did at the sentencing hearing?
Yes. But I say under B that he ought to have inquired at the sentencing hearing about whether the appellant knew he was entitled.
Yes, but what I'm trying to clarify, and I think you're confirming, is that your focus is on the sentencing hearing and not the earlier steps.
Yes.
Although the grounds of appeal are broader than that.
Yes, but the earlier steps, I say, do go to whether the hearing itself was fair.
Well, of course they provide context.
Yes.
But as I understand it, your real challenge is that the court didn't pause at the sentencing hearing when they had your client in front of them.
Yes. But in the context of this case, because there would have been no other occasion when the appellant had intended or engaged to have that pause and to have that reflection on whether he understood he had those rights or not. So I say this is quite different from Corrigan, a case which is a case from this court as well, and makes it clear that you do not have an unlimited time to take up the opportunity of legal aid, but we're in a completely different category here. If I may just go through the case law, and then I can explain why Corrigan is not applicable.
So is there anything more from King and Reed, or it's just...
Nothing more from King and Reed, thank you. I'll go in chronological order. So Newman, you. If you turn to tab 6, internal page 2567. Paragraph 23.
Yep.
Regardless of whether Mr. Newman asked for an adjournment to seek legal advice or representation, he was entitled under the Legal Aid Act to apply for legal aid. And then 24. In our judgment, it follows from section 29 that a court exercising any of the powers spelt out in subsection 1, so there that's the power to commit somebody, must A, have in mind its power to grant the alleged contemner representation, B, ask any unrepresented defendant whether he or she wishes to be represented, and C, if the answer is yes, consider whether to grant. Now, and then, sorry, the court goes on to say at that point you consider the convention rights. Now, the power to
underscored
grant...
by the convention rights, but yeah, I see what you're saying.
The power to grant legal aid is now with the LAA and the particular Nottingham division. But the LAA have not assumed the other responsibilities of the court as set out in this paragraph. And in particular in B, to ask any unrepresented defendant as soon as it appears that there's an appreciable risk of imprisonment, whether he or she wishes to be represented.
Can you just, for my note, tell me when the power went from the court to the LLA for the grant of legal aid?
So can I just take...
Yeah, of course, you know, doesn't need to be...
We think it was a decision in Mackay and All England Tennis Club.
I think that's correct.
Oh, I'm great.
Yeah.
My solicitor knows a lot more about the history of contempt than I do.
I think it was around 2019, if I'm not mistaken.
Because I think prior to that it had been uncertain.
And judges did. I mean, I'd done it, granted legal aid from the bench. It was one of those few ones where we had power to do so.
Yes, Court of Appeal still does, I think, and
Yes.
does it, but not the High Court.
Yes, that's right.
Mm.
But the point is this, the Legal Aid Authority does not seek out contemners and offer them legal aid. They do not have a dialogue at all with unrepresented defendants until the application is made, which by definition is when somebody has decided positively to exercise a known right. So the issue, if the onus does not remain on the court, is who is going to check that the contemner appreciates he has this right and has chosen not to. Now, I say Corrigan is simply a case where on the facts the court can infer that the contemner didn't want to exercise his rights and had a reasonable opportunity and chose not to. So that's Newman. We have Berry and Trade, Berry Trade Limited and Musavi now.
Yeah. Can I also ask for my note, where do you say if you're right on this, and obviously we have to hear both sides before making any decision. If you're right on this, what do you say the consequence is that we set aside the sanction that was imposed and then re-sentence?
Yes, I do. And if you want authority for that, that's exactly what happens in Hamilton and in Video.
No, I know that we have the power to do that. I just wanted to know what your submission was on that. Yeah. Okay. Thank you.
I don't think there's any point in remitting.
No.
Remitting this. So very trade. And I seem to have failed to. So it's tab 7, internal page 1918.
Yeah. Paragraph.
Paragraph. Sorry, I'm just. No, I might have referred to the wrong page. I apologise. I think it should be 1916 and the details have later discarded. So paragraph 30. The question which concerned the judge was whether or not it would be proper for the solicitors and counsel to act in these circumstances. As I see it, the question which the judge had to ask was a different question, whether Mr. Musavi had had an effective opportunity for applying for leave for public funding. The weight to be accorded to giving his opportunity must, in these circumstances, outweigh other considerations, such as convenience to other parties and use of court resources. And then it says that the court in that case did not. So there is a significant weight to be given to the contemnant's rights, which certainly in the circumstances of that case outweighs other considerations, and in my submission certainly did in this case. This was not a case where there had been repeated adjournments. There was not a case where there had been active interference with the court's processes. This is quite a different case of disengagement. While that is no excuse for, there is no excuse for disengagement, but to reason that disengagement itself means that the defendant cannot fully participate in a sanction hearing because of his prior conduct, then I say that there's a serious procedural breach. The next case is Hamilton, which is at tab 8 and page 1138. Towards the bottom, Lord Justice Moses at paragraph 11 begins, "In tutors and unassisted assistants the judge was, matters went wrong from the beginning. The judge noted at the outset that Mr. Hamilton was acting in person. He made no comment about it whatever. In particular, he did not ask anything as to the circumstances in which he was unrepresented." My lord and lady, that's what I say was an error of the judge in this case. And I say this duty to inquire into the circumstances as to why somebody is representing themselves has a long lineage from or even before Newman and bookbinders and through under convention rights now as well. Paragraph 12 of Hamilton. Once the judge had learned that the issue of legal aid was the subject of a review panel, which was due to sit in 2 weeks' time, there was no reason, so far as I can see, why at the least the committal hearing should not have been adjourned until the issue of legal representation had been resolved. By failing to ask appropriate questions at the outset, the judge deprived himself of the opportunity of receiving that information. And then at 13, in my judgment, the judge was blind to consider at the very outset of the hearing whether there should be an adjournment so as to enable the defendant to be represented. In my submission, the same principles apply here. This case is on almost all fours, in that the judge failed to inquire into why the defendant was not represented. In fact, this case is considerably stronger because he knew from what the appellant said that he had tried to get legal representation, but from the judgment there's no follow-up as to whether that was on legal aid or not, or when that occurred, to really bottom out why it was that he'd been unsuccessful in obtaining that. If we skip to Haringey and Brown, this is at tab 11, and on page 552. In paragraph 41. Another truculent contemner. It seems to me, forcing each of these submissions, one must have sympathy with the judge who was confronted with a litigant who in the earlier parts of the proceedings before him had not behaved well and who had displayed from time to time a tendency to extreme truculence. However, when it came to the committal application, the proceedings had moved to an entirely different phase. They were no longer civil proceedings, but had obtained a quasi-criminal character. The tenant's liberty was at stake. It was necessary to isolate the quasi-criminal application before court from what had passed before, to make full inquiry A, as to whether the tenant wanted legal representation, and B, whether it applied for the necessary funding to do so, and with what results. So, here on Navy again, my learned friend relies on the history of disengagement and the issues which Mr. Wang had in serving the appellant, in obtaining no response from the appellant. But I say that is all context, that is all in the entirely different phase of proceedings. One has to look at the contempt proceedings itself. The case law is quite clear that even the most truculent defendant is not only entitled to the right, but is likely to benefit considerably from the right. And I say, even within the contempt proceedings, it is the practice, rightly, of the court to treat the contempt hearing and the sanction hearing separately for very good reasons. And one needs to consider these rights at each step. O committal legal representation is a further case, tab 15. Lord Justice Peter Jackson, at page 200, 104, internal page 104. Halfway through paragraph 31, and then inside it says, However, when she was frustrated in obtaining representation, apparently on unvalid grounds, he should have taken further steps to resolve the problem, such as by making a representation order himself or by adjourning yet again on 13th of June to ensure that the refusal of legal aid was effectively challenged. And so that takes me to Corrigan, case which my learned friend places significant reliance on. this was a ticket tout case, and it was indeed a failure to engage, so it shares that similarity. But it was different in that at the same time that the contempt finding was made, there was a sanction passed, which was then suspended to give the contemner who didn't attend that hearing a time to comply before activation of the sentence. So on the return date, the contemner did attend, but at no point did he say that he wanted legal advice. So if one looks at internal page 2111, sorry, I'm just
47.
yes, thank you, my lady. As you will have seen, in Corrigan, the issue was that the facts were such that the court was entitled to infer that he didn't want to exercise his right, of course, which requires the court to be satisfied that he had been properly informed of his rights. If we go to page 2113, so just 2 pages on, in paragraph 51 at the top, there's also reference to, well, truculent statements, but also they're conveying no sense of apology or contrition or any desire to purge. There was nothing to suggest that even had the adjournment been granted to legal aid and legal representation to be obtained, the defendant would even then have properly engaged. You say it is correct for this court to consider and take into account subsequent events and the behaviour of this contemner. Now he has had legal representation. There is no reason at all to think that Mr. Darby would not have acted the way he has now if he had been advised prior to the sanction hearing. And then Lady Justice Asplin over at paragraph 61. And she distinguishes this case about 6 sentences down. I also note that this is far from a situation in which the defendant wants to be represented in committal proceedings but has been denied that representation. Although the appellant stated at one stage that he had consulted a solicitor, there was no indication that he wished to be represented, despite having been urged to take advice by Kernan. I say they are crucial differences from our case. If one looks at the actual judgment, which is in the core bundle, are you working off hard folders?
Yeah, I've extracted it, don't worry. Thanks.
And if one looks at page 75, the crucial findings are from paragraph 8 to 10. Can I invite you to read paragraphs 8 to 10.
Of the 24th of July judgment.
Yes.
Yeah. Thank you. Yeah.
Page 75. Oh, I'm sorry. The points that I particularly rely upon are that the appellant had not only attended this hearing, but he had been taking steps to do exactly what the judge had told him. Firstly, to obtain legal representation, and secondly, to put in evidence for the sanction hearing. Now, it was also entirely clear from this that he'd been unsuccessful in both. So he had unsuccessfully tried to get the legal representation. We don't know the details of that, but we can infer that it had likely happened from around the 16th, 17th of July. And secondly, he had put in what he called a defence statement. It was completely off point because it referred to the underlying contempt dispute and the findings of contempt. He had completely missed the need to put in any evidence of personal mitigation. He also admits he has not read the judgment. Now, the court expresses some doubt about that explanation, but 2 points I'll make about that. Firstly, as part of the picture facing the judge, whether or not he accepts that is a legitimate reason for not reading the judgment, the judge was faced by a defendant who says he hadn't read the judgment. Combined with the fact this was his first engagement, the judge clearly had in mind that there was going to be a significant prison sentence passed. And the fact that the appellant had told him he wanted legal advice and hadn't managed to get it. It was a relevant factor that the appellant appeared before him not having read the judgment, because that is exactly the purpose of legal representation, to go through a judgment and explain the basis on which the sanction hearing was going ahead. So I say, far from being on all fours with Corrigan, it is completely different in the category of the other cases I took you to, where the rights of the contemner were breached.
So that's your ground one, is it?
Yes.
Thank you. And then your next ground?
Ground three. Well, I can take this very shortly.
Well, it's really a different way of expressing ground one, is it, or is it separate?
Well, I say he was whether or not I succeed on that, to whether or not the court is persuaded that there should have been an adjournment for legal representation to be sought and obtained, there should have been an adjournment to allow for the personal mitigation evidence to go in, because the judge specifically says, I'm told that the wife, the partner, mother, daughter all have health issues, but there's no evidence before me. So I say, when you're faced with somebody who says this evidence could exist, it's incumbent on the judge to provide an opportunity for that.
I mean, the obvious response to that is the opportunity was provided by the adjournment from the contempt findings to sentencing, and defendant chose not to take that opportunity. I mean, some of your submissions do amount to really saying the court has got to wait for the defendant to choose to engage, and once he does, then you need a further adjournment, which really might be said to amount to the defendant dictating the time.
No, I don't go quite that far, but I do say that the conduct of the defendant at earlier stages should not disentitle him to a reasonable opportunity to exercise his legal rights going forward. Now, what is a reasonable opportunity is going to be fact specific, and it might take into account previous correspondence that said take legal advice, apply for legal aid, etc., etc. But there's no dispute in this case that the only two documents sent to the appellant prior to the contempt findings and the sanction hearing being listed is the application notice and the reference in the court order.
Can you just help me with paragraph, just on that particular point, paragraph 8 of the sanctions judgment, where the judge says, at the end of the judgment, I said I'd hold a short hearing by cloud video platform on the 12th of June. I sought to impress upon Mr. Darby the seriousness of the position and encourage him to seek legal representation. We're not told how the judge did that. And we all told in paragraph 9 in the first sentence that he didn't attend the hearing on the 12th of June. Do you know how the judge sought to impose on Mr. Darby the seriousness of his situation?
So I have read that as a reference to his judgment in the liability judgment at paragraph 63.
Yes, but the problem is that the defendant didn't read that.
Yes, but that's how I read it.
Yes, it does seem to link back to the wording of that.
Yes. So what makes this case different? I mean, the judge recognised that it was extremely serious, and he should consider obtaining legal representation and obtaining legal aid. But then, when it came to the actual hearing, and the appellant said, well, I've tried and not managed it yet, the judge went ahead anyway, and the defendant was sent to prison for 18 months. It's only the result of the appellant's daughter having done some further work and research after he arrived in prison that we're here today. That's all I have to say on ground 3.
Right.
Ground 4, I say it was open to the court to suspend the sentence on condition that the appellant disclose the existence and location of the Bitcoin. And this would have been an entirely suitable thing to do, particularly if one thinks about the sentence that was passed and the division between coercion and punitive. The judge obviously thought that there was a coercive element and some conduct by Mr. Darby.
Well, the judge assessed the coercive element at 6 months, and the at 12 months, and the punitive element at 6 months.
Yes, that's right. But for the same reasoning justifies a suspended sentence to.
Well, not at the time that the judge was giving the judgment, because there had been no purging of the contempt.
One of the reasons you suspend a sentence is on condition of belated compliance.
Well, but this is a serious breach for a freezing order, and there's lots of statements to the effect that that would ordinarily justify an immediate custodial sentence.
That's true, but one has to look at the particular circumstances of this case and the fact that the contempt was related to the 100 Bitcoin only, and in fact the respondent knew about the existence and location of the 100 Bitcoin before they'd even brought the main proceeding.
Well, they were pretty sure they knew, and Mr. Sanders had fairly flagged up that his degree of confidence went up between reports 1 and 2. I mean, which we've obviously had an opportunity to consider what the judge said and other materials. But that is different again from actually knowing and having it in your hand.
Yes, that's true.
Anyway, we've got your point. This is you say it should have been suspended.
I say it should have been suspended to give the appellant the opportunity to do what he's essentially done.
I'm afraid the courts rather take the approach that if you breach freezing orders, you go inside until you then sort it out, which happily has happened here, but it hasn't yet resolved everything.
Which takes me then to manifestly excessive. We say that the judge exceeded the reasonable range of sentences open to him, and if you're with me on the other grounds of appeal and are exercising your judgment on what sentence to apply now, the same factors I say are relevant, plus the apology admission earlier this week.
Well, that's so. I mean, in order to have a key to unlock, as Mr. Scott has very fairly pointed out, unless we find that this was procedurally wrong, i.e., your ground 1 and 3 tied up, then it will go back to first instance. But if we do find that it was procedurally wrong, because finally the chap had engaged and said he wanted legal representation, I hope that's a fair summary of your or short summary of your point, then it then does become for us to assess that, and obviously we assess that in the light of everything that we now know. And what are your submissions on sentence then?
Yes, sorry, just before we move on to that, my lord, just to clarify that ground 5 is also freestanding.
Yeah. That at the time it was manifestly excessive.
Yes. So my points at the time go to the fact that the judge seemed to have no consideration to the existence of personal mitigation on the basis that it wasn't evidenced. Now, that personal mitigation would have been relevant to the impact on his family, but also the medical evidence. Now, we now have that medical evidence.
That's the report from Dr. Sandcott.
Yes, yeah. And in my submission, that is relevant to what personal mitigation.
And what do you say that shows?
So if you can turn up that very briefly. Paragraph on page 35. And essentially, this bit of the report is dealing with the summary of the medical record.
Yeah.
So they could have been obtained for personal mitigation. You have there that at 1425 in 2017, the appellant was diagnosed with depression. If we go forward a page, so page 34, you have middle of the page, 30th November 2020, concerns about memory. And this predates the August 2021 order. The key here is that the judge appears to have considered the evidence of memory loss feeble, in his words. In my submission, whilst this psychiatric report does not go as far as to diagnose a condition which goes to culpability, it does substantiate the appellant's statements that he suffers from symptoms. Like
Yeah,
memory
but
loss
as
and
you know from the Sentencing Council guidelines on sentencing persons with mental disorders, the fact you've got a mental disorder, if it's unrelated to culpability, is not likely to have much effect, and if it's just background, is unlikely to provide any mitigation at all.
But in my submission, the issue here is that the judge, part of the contempt was a false statement as to whether or not he'd forgotten
Yeah,
the passwords or not. If the court had inquired into this memory issue properly, and this had been available, one would have seen that that was not simply an excuse made up for the proceedings.
but he's now admitted the contempt.
He has, so it would not have gone to whether or not he was in contempt, but it does go to culpability because the judge sentenced on the
Well,
basis.
doesn't it make it worse in some respects that you did have some memory problems and then you lied to try and use them? Anyway, it's not much mitigation. I understand what you say, but just so that, is there anything you want to say to that last point?
Just, I would say the opposite. He didn't lie about having memory problems, and the judge.
No,
because
but
it's-
lied about not being able to remember the password. You genuinely had medical problem,
Yes.
memory problem, and you abused it, the existence of that genuine problem, to lie that you'd forgotten the password.
But that's not what we say we did. We say we had forgotten the password, and you'll see in the letter yesterday
Yeah.
that we then found the note. But I say this would have meant that the judge would not have had such a dim view of the appellant.
Well, the judge had other evidence, didn't he, to reach the conclusions he did on that witness statement.
Yes.
We're not retrying. We're not doing a retrial.
Yes. No, I take that point. On harm, in my submission, this is a significant issue because the judge significantly overestimated implicitly the harm when setting an 18-month sentence. Whilst my lord points out that having a almost certain knowledge of an asset in its location is not quite the same as having 100% knowledge. This was not a case where there's been any harm caused by that.
Well, your strongest point is that there hasn't been actual dissipation, which is what the freezing orders are designed to protect against. So
Yes,
no
and
harm
we-
in that sense, but still a significant contempt in failing to list these assets.
Yes, and we admit contempt on that basis, but the court at the time was obliged to weigh up culpability and harm, and when the harm is that they've had to perhaps update a tracing record, then because there was a proprietary injunction, so the tracing would have had to be done.
Well,
in the event.
I'm certainly not going to stop you, but you will need, if you want to develop this line, to confront the fact that it is well known that cynical defendants can cause claimants to run out of money by just ensuring that they're not engaging. They have to do all the work. They have to pay all the expensive experts, etc.
Yes, but I think
Quite apart from the fact they're ignoring a court's order.
yes, but the report had been done prior to proceedings taking place, so that was necessary to get the claim off the ground anyway, to trace the assets. So Mr. Darby's breach and failure to confirm was just a failure to confirm. So, for example, you know, I have a house. Somebody else looks up on the land registry and sees it's registered in my name, but I refuse to confirm that. They still know I've got a house registered in
Well,
my name.
it's much easier to enforce against houses. You can go and get charging orders. You can't move the bricks and mortar. Bitcoin is slightly different. Anyway, we've got your point on that.
No, well, but that is relevant because the relevance of it being Bitcoin is that it's on a publicly available blockchain. So they would have seen if we tried to dissipate the 100 Bitcoin, and we didn't in any event. So that is relevant, and that minimises the risk of harm because one can visibly see it. And secondly, having the address does not help them freeze the Bitcoin because there's no one to go to like a bank, or there's no suggestion these wallets were on an exchange. It's still wholly within the control of Mr. Darby. So that's the relevance of the Bitcoin. Even if we'd have said, as we have now, we've got 100 Bitcoin and we think you're right about the location, that doesn't help them actually guess at the assets because of the nature of cryptocurrency. So the judge, in my submission, when looking at essentially a historic breach because they had the information that they were entitled to from us, passed a particularly excessive sentence. Now, I don't want to take up too much more time, but I will refer you to the case of Khan.
Just before you do that, and just only for the purposes of writing the judgment, the judge below had said that the estimated value of 100 Bitcoin was then $4 million. And what does anyone know what the estimated value of 100 Bitcoin is now?
I think it's over 8 million. Sorry, let me just check. Near 10. We think near 10.
Yeah. Okay. I mean, it doesn't need to be, but it's just obviously to make the judgment readable puts in these things.
Yes, and so the freezing limit in August 2021 was about $1 million, I think.
There's a post-judgment freezing order, though, we're told.
There is, which is closer to 2. I think.
Two, because it was 1 point with it 9 or something with interest, etc. Yeah.
Yes.
And costs. Yeah.
But either way, it was
well below that. Yeah.
Yes. So Khan, just quickly at tab 14, an internal 3848.
Yeah. Paragraph
64.
This was the medical doctor, wasn't it?
Yes. This is of general application in my submission. That the conduct involved, so I'm about halfway down, 5th line. The conduct involved in a contempt of this kind may vary across a wide range. The court must therefore have in mind that the 2-year maximum sentence has to cater for that range of conduct and must seek to impose a sentence in the instant case which sits appropriately within that range. Because that also links in to the need for the court to give the sentence which is least the least that meets the wrong. So for all those reasons, that we say 18 months was manifestly excessive in the circumstances.
At the time.
At the time.
And now, in the light of your, if you succeed on your ground 1 and 3 combined, then what do you submit the appropriate sentence should be?
Well, prior to the admission, I suggested 6 months, and he's already served over 5 months, so it will be 6 months, and then.
Well, 6 months
is
so he'd served how many months had he actually served?
Just under 6, 5. Sorry, let me just check.
It was 4.5, just under 5.
Oh, sorry, just under 5. It was.
It's just under 5, which is 10 months. A sentence. So,
and
but
now,
you said he'd served 6. You meant, in fact, just under 5. But that's not what the sentence is, because obviously we have to divide it in half.
yes.
So, what is your submission on sentence at this stage?
So I said the judge should have imposed a 6-month sentence, and now, in light of the acts of contrition and the letter the other day, I would say 3 months is appropriate in a case of this case.
If your 6 months takes account of a punitive element and also an element of compliance at that time. Right, okay, thank you.
Yes. Unless I can help any further.
No, thank you very much, and thank you very much for that helpful written submissions. Yes, thank you. Mr. Scott.
Thank you, my lord. In outline, what we say on ground 1 is that what was necessary was to give the defendant a reasonable opportunity to obtain legal advice and legal representation, not an indefinite number of opportunities. And we say that that was given. And I'll come back to that in more detail. I'm just outlining our
Your headline points. Yeah.
our position. On ground 3, we say that sufficient opportunity was given to evidence personal mitigation. Indeed, that was really one of, if not the primary purposes of the adjournment between the contempt trial and the sanction trial, but that in any event an opportunity was provided for personal mitigation to be given, which was properly weighed in the balance by the judge. And grounds 4 and 5 concern sanction. I accept in a forensic manner that they go to slightly different things, because one deals with whether or not the sentence should be suspended and the other one deals with the overall length of the sentence. But if I can deal with them in a headline way holistically, we say that the judge was plainly well aware of the legal framework and made a decision that was properly open to him, and that there's plenty of authority that appellate courts should be reluctant to interfere with sentences, and certainly shouldn't be in the business of fine-tuning sentences which are made below on the basis of evidence that was available to the judge below.
Fine-tuning or tinkering, I think it is sometimes called. Yeah.
Yes, exactly. So I'll start with ground 1. It seems to us in the course of those submissions that really ground 1 has distilled down to a focus on whether the judge was right to proceed at the sanction hearing. It doesn't seem to us really that it's being alleged any longer that the defendant was not made aware of his right to legal advice or legal representation it really seems that the attack is on the sanction hearing.
Yes, as I understand it from Miss Pugh, and correct me if I'm wrong. What she says is, yes, he'd been given this on paper, but the penny had not obviously dropped until guessed around 16th, 17th. And then he starts to find lawyers, all of whom say, this looks very complicated. We're not dealing with it without necessarily understanding. They're just representing him for the contempt hearings and
Yes.
and the details of that. And the chap comes in front of the judge and says, no one's representing me. And at that stage, what is submitted is that under common law, supported or underscored by the European Convention, the judge should really have said, look, what you need to do is get representation for the contempt proceedings. They don't really need to know much about Bitcoin. They just need to, they might give you advice on this and that. And that is really, she says, consistent with the authorities. And
Yes.
that I hope is a fair summary of how you put it.
Yes, thank you, my lord. As my lady observed in the course of submissions, however, what happened before then provides context, because in my submission, it's dangerous to simply look at the sanction hearing in a vacuum, because it didn't happen in a vacuum. It happened in the context of contempt proceedings, which were first indicated in 2021, but properly were not brought until after judgment. And then there followed from July 2023, when the application was made, a long series of steps taken both by the respondent and the court below to ensure that procedural safeguards were in place. So in my submission, it's still relevant to consider those steps, because otherwise the danger is one puts the sanction hearing on somewhat of a pedestal out of context. So
Yes, I'm just cutting to the chase though. If a judge is faced with a defendant who, for whatever bad reasons, has even good reasons, has just failed to engage with all of that correspondence, you know, with the forms that give the set out what the rights are, all the correspondence from your instructing solicitors and from the court, and it's apparent that that hasn't happened. How does that, the details of what has happened before, remain relevant context if it's obvious that the defendant hasn't actually engaged?
well, it's a somewhat difficult question to answer, because it depends somewhat on what we mean by lack of engagement. Clearly, on one level, we accept that the defendant did not engage, in that he did not appear at any of the prior hearings or take procedural steps that were open to him, such as putting in evidence. On another level, however, he did engage, because as you'll have seen from my skeleton argument and from some of the evidence, he was in email correspondence with the court below on the evening before the contempt trial on the 4th of June, setting out that he was aware of the proceedings against him, and then of course was later in correspondence with the court, having been served with the bench warrant application, informing the court that he was going to attend. So non-engagement is somewhat multifaceted, because in one sense he didn't engage, but the more difficult question, I suppose, is at what point in non-engagement does one say, well, actually, you have had your opportunity to take advantage of your rights? And what we say is that that opportunity had been offered on a number of occasions previously. And so when I get to the sanction hearing, what I will be saying is that it was open to the judge to proceed as he did, in the knowledge of the context of how proceedings had developed up until that point, because although it is dealt with quite shortly in the judgment, and I'm afraid what we don't have is a transcript of the hearing, which I think both sides accept would have been helpful. Although it was dealt with shortly in the judgment, plainly the judge was across the importance of the defendant's rights, because he reiterated those in the liability judgment. So the judge must have been aware, we say, of the consequences of proceeding, and you'll see when I take you to Corrigan that it's legitimate for the court to proceed and essentially say, as the judge is saying, Corrigan, that enough was enough. And if I tie that back to Article 6, 3C, I note my lord also referenced the common law rights to fair trial, and I accept those are slightly different. But of course, it's well known that Article 6 is not an absolute right, and of course, the crucial point there, really, which I will keep coming back to in these submissions, is this all hinges on the reasonable opportunity being given. Now, if on some counterfactual, the sanction hearing was the first and only hearing in the contempt application, and the judge proceeded, I accept my position might be very much weaker. But that was not the case.
So do you want to then just summarise briefly, or by reference to your skeleton, the steps you say which were taken?
Yes, my lord. Thank you. And in the interest of time, as long as you are happy,
Yeah.
I'd propose to do that by reference to the skeleton,
Yeah,
rather
no,
than
that's
taking you
fine.
to all the underlying documents, because I don't really think there's any contention. So if we go to page 9 on my skeleton,
Yeah.
This is I should say, this starts as strictly background. I don't attach too much weight to the first couple
Well,
of points.
it's really subpara 4 that you
Yes.
start. Yeah.
Yes,
Yeah.
because you've taken a note of the earlier points, but those were about the substantive proceedings, and I accept, as my learned friend has taken you to in the cases, that contempt is of a quasi-criminal nature and is materially different to what has gone before.
Yeah.
So yes.
And to be fair, he paid the penalty for not engaging.
Yes.
Yeah.
Yes.
I mean, that might or might not have reflected the merits. We're not here to
Yes.
decide that. Anyway, so starting
Yes.
at 4.
Yes.
Yeah.
So for the contempt application, as you're aware, since the amendments to Part 81 in 2020, there is a uniform form N600. Now, I know there's sometimes some debate about whether procedural forms are procedural rules, and they're not. But what's quite clear from both Part 81, particularly 81.4 itself, and the 2020 rule consultation, which I've cited in my skeleton, is that this form was created specifically to set out the rights that are captured in CPR 81.4, and of course there is a section on the contempt form headed "Your Rights," and it includes verbatim those rights that are captured by CPR 81.4, which includes right to legal representation and right to a reasonable opportunity to obtain legal representation and legal aid, which may be non-means tested. So that's on every contempt application now that is issued since 2020. The first hearing of the contempt application was listed for the 7th of September 2023. To be clear, that was never going to be the final hearing or anything like a trial, because the third ground of contempt, which relates to a false statement in the witness statement, is one which requires the court's permission. So it was always going to be an interim hearing on the application. It soon became apparent that Mr. Darby was evading personal service. On the day before that hearing, on the 6th of September, Mr. Wang made an application for service by alternative means, which was supported by evidence that service was being evaded. On the 7th of September, Mr. Darby did not attend the hearing, although in fairness to him, at this point, whilst we say he was evading service, plainly because he was doing so, there's no reason why he'd have actually had notice of that hearing. So it was only attended by Mr. Wang, and an alternative service regime was put in place, which included service at an email address which he was known to use, which is also the same email address that he later used to correspond with the court in the contempt proceedings, and via first-class post at his residential address. So then the contempt application was adjourned until the 27th of November 2023, and that hearing was essentially going to be the adjourned first procedural hearing on the application. Mr. Darby was then served by those alternative means. The email serving him on the 13th of September, sent by Mr. Wang's solicitor, explained the nature of the attachments and stated that he should not hesitate to seek legal advice. The hearing on 27th November proceeded, once again not attended by Mr. Darby. Further directions were given by an order of the court. Now, relevantly, we
Can you just show us that order? That's supplementary 18, is it?
Yeah, it's tab 18, so it starts at page 197. Now, particularly relevant to ground 1, my lord, we say that the court made a recital drawing attention to the defendant's rights as set out on page 3 of the Form N600 contempt application.
I have seen clearer references, but I mean, yeah, we got it. Yeah.
Yes, and I accept it could be clearer, but the clear logic behind it is upon being served with the order, the defendant would have seen or should have seen that recital and then looked to his rights.
Sorry, I interrupted your flow. So we're back now to that was 27th of November,
Yeah.
wasn't it?
That was 27th of November. Now, relevantly, because Mr. Wang was particularly keen to make sure that Mr. Darby was actually aware of what was going on and would engage with the proceedings, attempts to personally serve continued despite the fact that those were no longer strictly necessary. On the 10th of March 2024, there was an incident in which a process server who had identified Mr. Darby in a car park sitting in his car left a box of documents in the application which included the contempt application, whilst Mr. Darby remained inside it, refusing to come out. Then an email was sent on the 15th of May, because by this point we're under a month from the trial, asking whether Mr. Darby would be attending. That wasn't responded to.
Have they come off the record by now or not?
Yes. Mr. Darby's previous solicitors filed an application to come off the record the day before the disposal hearing in the underlying
before
proceeding.
the assessment of damages.
So whilst I believe that order was not processed until after the trial, for all intents and purposes the judge had seen the application and accepted that the solicitors were coming off.
Anyway, so this was to his former solicitors?
No, pardon me, my lord, perhaps I wasn't clear. This is an email sent by Mr. Wang's solicitor to Mr. Darby's email asking if he would be attending. On the evening before the trial, so this would have been the 3rd of June, the court received an email from Mr. Darby's email address. Now, we only found out about that on the morning of trial itself, and the court was reluctant to share the contents of the email, save to say that it was clear from the same that Mr. Darby was aware of the hearing that was happening the next day.
Do we now have that email?
No, my lord.
No. Okay.
So the next day, the contempt trial began. Mr. Darby was not in attendance, which we say it's clear was a conscious decision in light of the email the night before, and that there's not really a sensible conclusion that can be drawn apart from that. Now that leads to something which I think is no longer really in dispute, but it's the judge's decision to proceed in Mr. Darby's absence.
Yeah.
And as you may well be aware, generally that decision is taken by reference to a checklist of factors in a first instance family case called Sanchez and Oboz, which has been approved.
And which picks up the Jones factors from the House of Lords in criminal trials.
Yes, exactly. So that really is the key point. It's rooted in criminal considerations. It may assist if I just turn that up very
I'm
brief.
not sure this aspect's being relied on. So
Yes, well, in which case I can move on.
Can I just ask before you do?
Yeah.
There's reference to the judge giving an extempore judgment dealing with the Jones-Sanchez factors.
Yes.
We don't have a transcript of that.
No, there's not a transcript, and I'm afraid I'm unable to say why that is. Obviously, it would be preferable.
No, don't worry.
to
It's
have
just
it.
I hadn't seen it. In
Yeah.
the same way that we don't have a transcript of the sanctions hearing.
Yes,
Were efforts made to obtain a transcript of the sanctions hearing?
that I
Not by
Don't-
your side.
that I don't quite know. In fairness, it may be for Miss Pugh, but I think
Yeah,
what
well,
was,
I'll ask
Yes.
this for you. But your side haven't asked for it. No.
No.
Okay, that's fine.
no, my
Right.
lord.
So we were up to the 4th of June. Yep.
Yeah, and just the one thing I say of relevance about Sanchez and Oboz is baked into those considerations, if you like. The court has to consider whether an adjournment would help facilitate legal representation for an absent defendant, and I can't really put it any higher than this, which is that we don't have that extempore judgment, but plainly the judge weighed the checklist factors in the balance and came out in favour of proceeding. So we don't have reasons for that conclusion. All we have is the conclusion. But what I can say is plainly the factors were taken into account. I referred in my skeleton to my earlier skeleton, which set out those factors. Now what did happen, and this is increasingly common in cases where the defendant is absent, is that the judge decided at that stage that the trial would be adjourned after submissions on contempt and the judge's findings, rather than proceed immediately to any sanction, if indeed there were to be sanction, because historically often the two have been bundled up together in contempt trials. But in cases where defendants are absent, there's a practice of court that's been developing where an adjournment is favoured, and really the reason for that is, one, it allows the defendant properly to reflect on any findings, two, to think about securing legal advice or legal representation, and three, to provide a sufficient opportunity to prepare any evidence for any sanction hearing, which really, in a nutshell, is evidence of personal mitigation. And you will see when we come to look at the order from the 12th of June, that's really what that order provides for. Those directions down to the sanctions hearing are really designed at giving the defendant a final chance to get involved. You will also see, so that decision was made. Then obviously the trial continued in Mr. Darby's absence. Judgment was handed down remotely on the 10th of June.
Included paragraph 63. We've got that, and then you have the 12th of June. Is that right?
Yes, yes, and I should say, just for completeness, although it was somewhat of a tight turnaround between the 10th of June hand down and the 12th of June, Mr. Darby was served with the judgment and the notice of hearing for the 12th of June, and did not attend the hearing on the 12th of June. The order from the 12th of June, we can turn that up. Probably helpful. That tab 3 of the core bundle.
Yeah.
So we've got a number of recitals which just set out the background, and then a long section recording the grounds of contempt which have been proved. Then the order itself is on page 38. Relevantly, Mr. Darby was required to attend the sentencing hearing in paragraph 2. That order quite clearly been made in the context of his non-engagement to that point, and also likely in an attempt to prevent the need for something like a bench warrant. And then deadlines for giving evidence as well. You'll see it paragraph 4. I should just say as well, in an effort to be helpful, paragraph 5 deals with time running for permission to appeal. As you might be aware, where findings of contempt and sentence are split up, permission is needed to appeal findings of contempt, because they don't at that stage relate to deprivation of liberty, because there's no committal order at that point. And so generally what's done to help defendants procedurally is to push off time running for that until after any sanction has been made. So again, these are facets of the order that again are being made to assist Mr. Darby should he choose to engage. That takes us to subpara 14 on page 11 of my skeleton. So at tab 31 of your supplementary bundle, you've got a number of items of correspondence which were sent by Mr. Wang's solicitor to Mr. Darby. Turn that up just very briefly. So, for example, if you look at the letter on page
246, which is the notice of hearing, is that right?
246 is one of these letters. The point is really that a number of these letters and emails which were sent to Mr. Darby between the liability hearing and the sanction hearing urge him to seek legal advice and to consider applying for legal aid. Now, not every single item of correspondence says that, but my submission is it wasn't necessary.
Which ones can you just identify which ones?
Yes, I appreciate this bundle is not
242.
paginated. Yes, so 242. 246 does. (248) as well. 250.
Right.
I think that probably suffices. But in any event, that, as I say, at this stage of this appeal is only context, because it's not really being pursued by my learned friend anymore that the respondent had not made Mr. Darby sufficiently aware of those rights. But the fact remains, looking at this correspondence, that we say the respondent was going above and beyond what he was required to do by repeatedly reminding.
And he was threatened with the bench warrant on the 8th of July. Is that right?
Yes, and that was made at a time when no response had been received to any of those emails. In fact, it was filed on the 17th of July, my lord.
Yeah, but the letter warning him was sent.
Oh, sorry. I see. Yes.
Page 250.
Yes.
Yeah.
Yes, the letter was slightly earlier. Yes, but there was no reply to that. So that prompted the application,
Which was 17th of July.
Yes. The court made an order without a hearing on the 19th of July, which page 259 of that supplementary bundle. It should be behind tab 34, which refuses that application on the basis that Mr. Darby had emailed the court on the 17th of July stating that he would be attending the hearing. Again, we say,
Presumably that email was in response to the application.
yes, that's what we say. It appears to have come pretty much instantaneously following service of the bench warrant. But that leads to a slightly wider point here, which is that whilst one naturally has some sympathy in complex litigation for the mountain of paperwork which may be received by a litigant in person, what's quite clear when one looks forensically at the evidence here is that Mr. Darby was very much capable of responding quickly to what he received when he wanted to.
So, in fact, no bench warrant was ever made.
Yes, no bench warrant was ever made because Mr. Darby confirmed that he would attend the sentencing hearing, and then did indeed do so.
So in response partly to what I said earlier on, he in your case is he responds straight away to being served with an application notice for a bench warrant.
Yes. So the point is that
Telling the court that he's capable.
yes. So in that respect, the non-engagement is somewhat selective, and in fact, the description in the sentencing judgment, which of course we will look at in due course in relation to other grounds of appeal anyway, that the judge utilises, that it appeared to him that Mr. Darby had buried his head in the sand, which we say is really quite an apt description. And that goes back to my fundamental point at the outset, which is that if a reasonable opportunity has been given to a defendant to obtain legal representation, legal advice, but the defendant has buried his head in the sand, it's then open to the court to proceed, not to go back to square one and say, well, you might be engaging now a little after when you should have been, so we'll grant an adjournment. Because were that to be the case, one can quickly see that many contempt applications might descend into a cycle of somewhat unmeritorious adjournments being granted, because of course what a court has to weigh in the balance if an adjournment is in prospect is what are the prospects of legal representation actually being secured and any hearing coming back on being effective. And of course it's relevant, we say, looking back to those Sanchez and Aboz factors, that the judge has had to consider that very factor in deciding to proceed in Mr. Darby's absence at the contempt trial itself. So we say it can't properly be said that the judge didn't have these important factors in mind, because in fact he'd already exercised them at the earlier hearing on the 4th of June.
So that brings us up to the hearing itself
Yes.
and the judgment, which we've had an opportunity to see. Can I just ask you to deal with a point Miss Pugh made, which was, I mean, to this effect?
Yeah.
Fine. He obviously knew what was going on. He had, as the judge put it, perhaps accurately, put his head in the sand.
Yes.
But finally, when he does ask for the, it says that I have been trying to get lawyers, but can't get any, and then gives a description that any reasonable judge is likely to know means that he's been telling the lawyers all about the case rather than the contempt proceedings. It's at that stage that the judge should, I think the submission goes, have cut to the chase and said, look, you are entitled to free representation. You need to be represented because you're going to go to prison, very likely. Go and get a lawyer. And Miss Pugh says not only should the judge have done that as a matter of good practice, it's justiciably wrong not to have done it.
Yes. Well, I think the point is that the judge has, we say, a discretion whether to proceed, and that is the case in Corrigan, which I can turn up again. It may be helpful to come back to that, but it really goes back to the fundamental point that what the defendant needs to be given is a reasonable opportunity, and although the reasoning is quite short in the sentencing judgment on this point, it would appear that the judge proceeded because numerous opportunities had already been given to the defendant. The other thing I would say is, without the transcript of the hearing itself, it's very difficult to know exactly what was said. The judgment records that Mr. Darby had told the court that he'd contacted a number of solicitors who had declined to act. What's not clear from that was whether Mr. Darby was actively stating at the hearing that he continued.
Well, you were at the hearing. I mean, does your solicitor have a note or anything like that?
We have notes, but they are incomplete, and so the decision was taken that those notes shouldn't be properly relied on by either side, because the danger then is that they take on the status of something like a quasi-transcript.
Yeah, well, no one's given us a transcript, so we'll have to do the best we can.
Yes. Yes.
You want to take us to Corrigan?
Yes, I will. I will take you to Corrigan just briefly.
Divided 16.
Yeah. Yeah, 16. So there are lots of similarities between the two cases. We don't need to dwell too much on them at this stage, because in fairness you've been taken through that decision already. But what one sees, for example, if you look briefly at paragraphs 19 and 20 of that judgment, is the court recording that this is a case where the defendant had been told on a number of occasions to seek legal advice. if we go to paragraph 29, which concerns the hearing on the 30th of July, which was the hearing which Mr. Corrigan did attend for the first time, having failed to engage previously, and at which his suspended sentence was activated, it's of interest that although primarily Mr. Corrigan sought to explain his non-engagement by reference to mental difficulties, right at the end of paragraph 30, it said that he briefly indicated that he had on an unspecified occasion spoken to a solicitor. So there was also in that case seemingly some attempt by Mr. Corrigan.
But I think a key distinction relied on is it's one thing to say I've spoken to a solicitor. It's another thing to say I've provided legal advice and not been successful in doing so.
Yes, I accept there's a distinction of degree. In my submission, though, it still ultimately leaves the court with a decision to make about whether to proceed, rather than it taking the court into a realm of, well, I am obligated at this stage to ask certain questions or grant an adjournment. And I think that's really where I differ.
Is that right? Is one reading of Corrigan that your and O is your the distinction is where someone really deliberately makes a deliberate decision that they do not want to engage with lawyers? Isn't that what one reading of O and Corrigan?
Yes,
Whereas
well,
in contrast, respondents who do in fact want legal representation should be entitled to have it.
yes, the difficulty is that really what the court focuses in on Corrigan is it's about truly wanting legal
Well, indeed,
representation.
That's where I think Ms. Pugh seeks to distinguish Corrigan on the facts, and this is not. Mr. Corrigan appeared to evidence that he did not want legal.
One of the problems we face, again going back to the fact that we don't have a transcript of the hearing, is that what the judge below the judgments records is that Mr. Darby had contacted a number of solicitors. It's wholly unclear from that the extent to which he was seeking to engage legal representation. Much in the same way that in Corrigan it's clear that Mr. Corrigan had consulted with a solicitor. It's very difficult to say without a transcript.
Well, we have a judgment, and
Yes.
that's what we're
Yeah.
stuck with.
Yes, exactly.
And
exactly
as
that.
you fairly point out, what the judge says in this respect is pretty short, but we have to read it obviously in the context of what's gone before.
Yes, I accept that.
And it's all in paragraph 10, isn't it?
Yes.
He told me that he'd contacted a number of solicitors, but they declined to act, apparently because of the technical nature of the proceedings or the underlying issues. And inferentially, I imagine you don't dispute the fact that this must have been 16th or 17th of July, after the sort of bench warrant issue has sort of raised and been determined, because he's not engaged before then. And I mean, if you read that fairly, it does rather look like without in any sense being rude to Mr. Darby, that he's asking them for representation in these proceedings for a hearing on the 24th of July. He's telling them it's all about Bitcoin and it's millions of pounds, and he's in contempt of court. I think most solicitors would perfectly reasonably say, well, I'm very sorry, I can't help you on that. Rather than you're about to be sent to prison because you've disobeyed court orders and courts take their orders seriously.
Yes.
Dealing perhaps with a submission Miss Pugh made about freezing orders, and you need to be represented. And when someone has actually finally engaged, but engaged in a hopeless way, rather like he's engaged hopelessly by asking for the wrong thing from solicitors. And you're right, it is a discretion, but is it not a perverse exercise of the discretion not to say, right, because it's in the court's interest, it's in your interest, it's in their interest, actually to try and resolve this thing. What you want is the money out of him and for him to be punished for his breach, but fairly.
Yes, I take those points on board, my lord. What we say is that it was a proper exercise of the discretion, because I really go back to my headline point, which is that what was key was for the respondent and for the court to ensure that Mr. Darby had a proper opportunity to obtain legal representation. What's clear from the evidence was that he had not just one proper and reasonable opportunity, but several. And so, again, one has to say this inferentially because the reasoning of the judgment is short, but it would seem that the judge had reached the view that enough was enough and it was time to proceed, because numerous adjournments had been made previously due to the defendant's non-engagement and in order to ensure procedural safeguards. And now that he was finally there, one infers that the judge's view was that it was time to proceed and not to waste further court time and resources, because there's also, of course, a legitimate interest in determining court processes expeditiously. And these proceedings, these contempt proceedings, which I accept involve technical expert evidence, but otherwise are not particularly complex allegations. They're short allegations in which the evidence was essentially unanswerable. And that whole process, which could have been dealt with otherwise fairly quickly, took almost a year because the time and care was taken to provide those procedural safeguards. So the point is, I suppose, if that process is not enough, what standard should the court below or respondents properly be held to? Because it would appear then that the process is made interminably slow through the fault of defendants for voluntarily burying their heads in the sand. And that's an important factor for courts to weigh in the balance, because real prejudice is caused by that delay as well, and that's something that has to be balanced against the defendant's rights, which, as I say, were not absolute, and those rights had been properly respected already by that point in time. So I think that's probably as much as I can usefully assist you with on ground one.
I think that's very helpful. And then you've gone beyond your 45 minutes, and Ms. Pugh has to have things. We'll sit till 1 so that you both have a fair opportunity to decide that. So your ground 3 was there was a failure to take into account mitigation. What do you say about that?
We say that, well, I think strictly what is said on ground 3 was that it was a failure to adjourn the sanction hearing of the court's own motion in order to evidence personal mitigation. We say that's wholly wrong, because firstly, a sufficient opportunity had clearly been given to evidence personal mitigation, as is clear from the terms of the 12th June order. And secondly, in fact and in any event, as is a core right at a sentencing hearing, Mr. Darby was given the opportunity to evidence personal mitigation, and he did do so, and that is clear from paragraphs 20 to 22 of the sentencing judgment. And what is notable from that is that the majority of the mitigation that was offered was accepted by the judge. So the mitigation was clearly weighed in the balance. It was accepted that Mr. Darby was a man of good character. As for any mental health difficulties, the judge fairly ruled on the evidence available to him that didn't take matters much further. And in my respectful submission, the report you've now got before you really doesn't take matters much further either. So that in my view is a non-starter. The judge also accepted evidence that Mr. Darby's members of Mr. Darby's family were unwell. He did not consider there was evidence cause that significant hardship would be caused. It is difficult to see in reality how an adjournment for further evidence.
Well, it would only be if he had significant caring responsibilities, which is a specific factor to be taken into account.
Yes, and in any event, it's recorded in the judgment that there was no evidence he did have a significant caring role, which one infers is because he didn't state that to be the case. So as the judge says at the end of paragraph 2, at 22, I accept these matters and I take them into account. So really the short and fatal blow to this ground is the judge did give Mr. Darby a chance to consider to evidence personal mitigation, and the judge took it into account.
And then on the first way in which combining grounds 4 and 5, which is what is the appropriate sentence and whether it should have been suspended at the time, before we address you, if we're against you on ground 1, which obviously we don't know yet because my lady and I have to decide that.
Yes.
But we'll obviously need to have your submissions on both.
Yes, of course. So ground 4, again, it starts off on the wrong foot because what it actually says is not just that the judge was wrong not to order a suspended sentence, but also he was wrong not to consider a suspended sentence. It's plain that the judge did consider suspending the sentence. That's at paragraph 26.
Yes.
The judge, and this I accept, bleeds slightly into ground 5, as indeed it properly ought to, because sentencing and the principles on it are a holistic process. The judge had the appropriate legal framework before him. There's no real issue here as to the fact that these are serious contempts, a breach of a freezing order, and making false statements in witness statements. I can take you to the authorities if I need to, but it's pretty clear from those authorities that those sorts of breaches normally merit an immediate custodial sentence. And the judge, having then considered whether such custodial sentence should be suspended, it's clear we say that he reached a decision that was open.
In Newman, did they make reference to the Sentencing Council guideline on suspending sentences?
In the Newman case, I'm not sure,
because there are 3 factors in support of immediate imposition, 3 factors against in those guidelines.
Yeah.
Which one's meant to go through? But you say that the seriousness of the offence, reading it across to the contempt, means that this should not be suspended.
Yes, and in any event, it's not a black and white question because it's a question of judicial discretion. And it's clear from the judgment that the judge did consider suspension and came down against it. Now, it's irrelevant that other judges might have reached a different conclusion because what's necessary is to review the judge's decision rather than
Well, to show it's
subs-
justiciably wrong, yeah.
yes.
And what about the complaint that this is, in any event, simply too long for failures to disclose?
My lord, once again, somewhat echoing what I've already said, it's plain that these are serious offences. What is the main point that seems to have been taken, at least in writing and to some extent pursued orally, is that there ought to have been a less severe sentence because it said that Mr. Wang already knew about the existence of these 100 Bitcoin. If I may, that's a somewhat fallacious argument, because in order to prove that there has been false asset disclosure, one needs evidence which goes to why that asset disclosure is false, which necessarily means that one probably needs evidence that there's something out there that should have been disclosed and wasn't. Indeed, if that wasn't the case, it would be abusive and wrong to be bringing contempt applications based on those very allegations. So that's a somewhat circular argument which doesn't really go to the sentence. Again, I think that the basic point is that given that the judge was properly seized of the appropriate legal framework and rightly decided that these were serious breaches, one of which in substance, although not technically a continuing breach, because under a freezing order the way matters work is that you have to disclose within X number of days, but in substance is a continuing breach, if you like, because it's easily remedied at any point to correct false asset disclosure, and it's pretty clear on the authorities again that those generally merit pretty substantial prison sentences. So again, the basic point is that other judges may have reached slightly different sentences, but it's clearly not manifestly excessive and
Or wrong in principle?
yes, and I go back to the basic point in cases like Nichols and Chelsea Football Club, that really what an appeal court is doing is looking at the sentence in the round, asking whether it's proper rather than fine-tuning or tinkering with the sentence below. So those really are my submissions on ground 5. I apologise for having gone slightly beyond my time, and I'm grateful for the indication
Don't worry. I mean, the most important thing is to try and ensure we're fair to both sides, and that we can deal with that. That then leaves you to address the point that if we consider that Miss Pugh's ground 1 is right, because and it's tied in really with ground 3
Yes.
on the mitigation point, and that the judge should have given an opportunity, then we would set that aside, but we would then re-sentence.
Yes.
But obviously re-sentencing as of today.
Yes.
And what are your submissions on that? I mean, Ms. Pugh said it should have been 6 months, and if you're resentencing today, taking into account of everything, it should be 3 months.
Yes.
What are your submissions?
Well, my lord, I think it's probably right for me to adopt my position below as if sentence hadn't happened, and that position was that whilst claimants in contempt applications may have some legitimate interest in advocating on what a sentence should be, the exact mechanics of working out the length of a sentence is really a matter for the court. So
well, that's very fair, and it's really just to give you an opportunity
Yes.
to deal with that.
But what I would say, my lord, is that it is clear that the custody threshold is still met, and that is really as far as I can properly pursue it. And then at that stage, it is a matter for whoever comprises the court on any given day to properly weigh the factors in the balance in working out what they say the appropriate custodial sentence is.
Okay. Are you going to comment separately on the recent developments then? Because you indicated you made some comments about that at the start of the hearing.
Well,
I mean, there's been an offer, it is said, to purge the contempt by
yes.
an immediate transfer of £1 million worth of Bitcoin.
There are a number of issues there. That the first is that the strict purging of the contempt, and I take my lord's point about the broader point I was making earlier versus the particular contempt that we have pleaded, but the strict purging of the contempt, if one looks at it in the narrower way that my lord indicated.
Well, that's what the order
yes,
was.
Yes.
That's not to say you can't do lots of other things.
Yes.
But I mean, we're here with the order. I mean,
yes. Yes, I appreciate that, but the strict purging of the contempt involves giving rather more detail.
Does it?
You see, if you look at divider 4, page 1, which is the sanction order, where it's just that in breach of paragraph 13.1, which required him to do the defendant failed to mention the existence or location of 100 Bitcoin. He said now, very sorry, and here is where the 100 Bitcoin is.
Well, he said that they're on the blockchain.
Or am I missing?
Yeah, he said that they're on the blockchain and are publicly at a location that's publicly available. What he's not done is given a complete inventory of that and precisely where they're located. So it appears to be a step in the right direction, but I'm not sure that it's technically purging. The second point is that the offer to transfer £1 million is a somewhat curious one because
that's not. I'm not interested in that.
Yes.
I mean that's because that's not purging the contempt. And
yes,
that's
well,
what we're dealing with.
That really was my that was going to be my short point on that. But our point is we say it's not really good enough to bring this up at the 11th hour before an appeal and expect us to have had enough time to properly take advice and think about whether in fact.
Well, we are where we are.
Yes.
In the sense that if there's only arises that you're right, if Miss Pugh is right, and we have to re-sanction. If you want to adjourn it for re-sanctioning, fine, but I'm not encouraging that in the slightest. And I mean, it's apparent that the parties have cooperated, and we're very grateful for that, and have had other discussions, and we're certainly not in the slightest bit interested in that. What we wanted to know was your submissions on purging contempt. And you say that he's failed to mention the location of approximately 100 Bitcoin. Is that right?
Yes. But what he said on page 2 of this letter.
Hang on, because obviously it only came in yesterday.
Yes.
Well, what he says, he can't confirm the location as he has not logged on to check. But there's no reason to believe the locations outlined are incorrect.
Yes. I'm not suggesting for a moment that given proper time to consider something as serious as whether contempt and purge, we might ultimately form the view that in fact it has. But in the context of this developing at the 11th hour when everyone was busy preparing for this appeal.
I understand that, but we have to make a decision. I mean, you are perfectly entitled, to, even at this 11th hour and 59th minute, to ask for an adjournment on this point, but that will depend on whether Miss Pugh has succeeded on ground 1.
Yes, I understand that, my lord.
I mean, the grim reality of it is this: he has served 9 months, and the judge said, assuming the judge was right on his sentence, 6 months, but with 12 months as the coercive element to do that, which would suggest that if that is right, then any order we make is likely, if Miss Pugh is right on ground one, to result in his release.
Yes. Yes, I
And that's
accept
why
that.
it is a material factor for us to deal with. If you are saying, I can't make submissions on this, well, fine, we'll have to consider that and then make a ruling on it. But if not, you'll have to do the best you can.
Yes.
At the moment, we've got that he said that in terms of location, right? And Miss Pugh can, in the 20 minutes remaining, and come back to that. On point 2, that he, the witness statement, well, he said, I provided a false one and I'm very sorry. So what else can he do?
Yeah.
Okay, and similarly, 3 is the same point, isn't it? So it all comes down to whether the location is sufficient.
Yes. My lord, if I may, I suggest,
Of course, yeah.
I suggest we deal with it this way, which is Miss Pugh has a right to reply, which will give me a chance to take instructions, and then I can write at the end before the hearing ends. Give you my updated position on that, if you like.
Yeah, that is fine. I have to meet some judges from Ukraine at 1 o'clock, but if necessary, you can all come back this afternoon. I mean, at the end of the day, we don't want this to drag on ad infinitum. We want to be fair to that side and to your side, and to try and deal with this.
Yes,
Of course, it's always a delight to see you on another day, but I don't imagine anyone wants that.
Yes, my lord.
Right,
Thank you.
carry on. Yeah, so that's your point, is effectively that the location is not clearly articulated.
Yes, my lord, but I will take instructions.
Yeah, okay. Ms. Pugh. Of course, yeah.
Very briefly then, coming back on reply, there's a danger of eliding the reasonable opportunity to participate in the contempt hearing and the reasonable opportunity to participate in the sanction hearing. This judge accepted, I say rightly, that as of the 10th of June, the opportunity to participate in the sanction hearing had not closed. That's why he adjourned the hearing and made directions on the 12th. So essentially all the smirking of the appellant, rightly or wrongly, prior to that point, have more force if it related to the contempt hearing.
But that's, I think, Mr. Scott's point is, well, that's a month and a half before the hearing, and they're sending you letters saying you've got to turn up and you've got to get legal advice.
And if he hadn't turned up and he hadn't engaged at all, then 6 weeks may well have been perfectly adequate and an appeal would not have gained any traction. But he didn't. In that 6-week period, he did 2 things that the judge asked him to do, both of which unsuccessfully.
So
One
not
was
in the 6 week, in 6 days. No.
Well, yes, but
Yeah.
but the judge clearly thought, I will give him an opportunity. He has the right to an opportunity to take legal advice before the sanction hearing. So that is the maximum period, I say, one takes into account. He, in fact, only had a week in practice, and the previous adjournments that my learned friend refers to are not related to the sanction hearing. There would have been no prejudice to the respondent in having a further 2-week, 3-week, 4-week adjournment, whatever it might have been. So I say, quite properly, one has to look at the sanction hearing separately. the second point, just to clarify, sanctions and obas, I'm not pursuing any point arising out of that.
Out of
sanctions and obas, that was ground 2 potentially.
yeah.
So that doesn't apply.
Sorry, that was the deciding to proceed with the contempt hearing.
Yes. Yes.
Liability
Yeah.
hearing.
Yeah. Then ground 3.
Sorry. So yes. Point 3. Sorry. The 27th of November order that you were taken to, where there is a recital which says that the appellant is reminded of his rights set out in the application notice. This is perhaps a significant point in other cases, so we do not accept that as a proper approach. Might make no difference in this case, but for the benefit of contemners, expecting them to cross-refer to documents, which many of them won't have kept hold of, in my submission is not enough, and guidance on the approach to be taken by the court.
Well, whether we
may
give
not be right.
guidance is at a different point. At the moment, we're just determined to try and deal with this fairly. Next point.
Next point, selective engagement. Again, that is very unfair in my submission and relates to the time prior to the contempt. There's no, in my submission, selective engagement in the run-up to the sanction hearing. He was required to serve evidence. He did. It was completely off point, but that's because he was unrepresented. And he attended the hearing, which he was also required to do, and he had tried to get legal representation. So there was absolutely no evidence of selective engagement for the sanctions hearing. I don't dispute fifth point that the custody threshold has been met. The question is whether the sentence at the time was manifestly excessive. I've given you the reasons why we say it is.
Yeah.
And also within section 13, obviously this court has broad power to vary sentences and take into account the amount of time that Mr. Darby has already spent in prison and the consequence on him if he goes back in. The issue of disclosing the location, as I've already addressed you, the location of the Bitcoin is known because it's on the blockchain. Mr. Darby has not logged in because he's waiting for this hardware wallet because of security concerns. So that's set out in the final penultimate paragraph of the letter, explaining that he's awaiting delivery of a hardware wallet. In the interim, the best he can do is say that when he logs in, he's fully expecting to be able to confirm that location. He's got no reason to think not. I've taken instructions and he's willing to undertake to provide that confirmation within
Confirmation of what?
days of the location of the Bitcoin. So what he says at point 2.
Yeah, no. But I just wanted to know what confirmation.
Yeah, so once he's logged in and he's not there now to take delivery of the hardware wallet, so I'm suggesting 14 days to enable. I don't want to set a deadline to set him up for a fall. So 14 days, he can log in when he's got this hardware wallet and he can 100% confirm it's there. If that's the technical issue,
So at the moment, what you say is that in fact, although technically he hasn't confirmed the exact location, he's done the best he can, and he will within 14 days sort out the balance.
Yes.
Yeah. Okay. Thank you.
Thank
Mrs. Scott. Oh, sorry.
No, I think that's, unless I can assist you. Oh, sorry. One.
Yeah. No. Of course. Yeah. Yeah.
On my point about section 13 and the breadth of it, my solicitor has rightly pointed out the Court of Appeal decision in Turk, where the court granted what it referred to as mercy for a defendant contemner who had been in prison, released on bail, and in the circumstances of that case, although there was no criticism of the first instance judge, the Court of Appeal nonetheless.
So despite not allowing the appeal?
Yes, it allowed the appeal on sentence on the grounds.
Well, it didn't find an error in what the judge did, I think you're saying.
Where is Turk?
Yeah, sorry. It didn't make the cut, but I can
No.
I can send it over.
Well, as long as Mrs. Scott has. Well, we'll look at that anyway. Right. Thank you very much, Mrs. Scott.
My lord, in the circumstances, and particularly in light of the helpful indication that there's an undertaking forthcoming, we're prepared to accept that, for all intents and purposes, what set out in the letter does amount to purging the contempt. So that's removed that from the list of
Which,
issues.
on the judge's analysis, meant that 6 months was for the immediate custody for failing to comply with the order and lying in the past, and then the rest was to encourage compliance. What a complete mess! Because of course, if we dismiss the appeal, then we're not going to interfere with that anyway. But obviously, I don't think we want to start getting into the business of accepting undertakings. We'll record that you've said that, but I mean, undertakings endorsed with penal orders, there have been quite enough contempt of court as it is. So we'll note that you've done that. But that does mean that even if we dismiss the appeal, you would be able to go to court having provided that further information, and it would be an agreed application for the contempt be purged.
Yes.
Yeah,
I think
on the basis that, assuming the next judge accepted, and if we were against you on ground one, we'd make it clear that would be the position, that this was a reasonable allocation. Your client would now purge the contempt, which equals 12 months, and has already served the equivalent of the 6 months.
Yes, if I may just say 2 small points. I would ask the court to determine the appeal in my favour nonetheless.
No,
even though we can't
I entirely understand that. We're going to have to go away and write a judgment, and you are then going to have to determine. If you win the appeal, then it is likely, especially in the light of that helpful comment, that in any event, resentencing today, we would adjust it, which is likely to be equivalent to time served or less, given the realities. If, on the other hand, we're against you, we don't have the power to do the purging of the contempt because the application's not made to us. But in the interim, he's on bail, so he's not going to suffer any things, and we will order bail to continue. But we'll have to give the judgment on this, even though, as a matter of reality, whether it'll make much difference other than to the law, given that there is a possible way through, assuming, of course, that he does what he said through you he will do within 14 days.
Well, I think you don't have jurisdiction to decide a purging point in this appeal, but I think section 13 will be wide enough for you to reduce his sentence to take account of that in my submission.
What, as fresh evidence? Hmm?
You can.
Yeah. But I mean,
just-
that's not actually how the appeal's been put, as it were,
Yeah.
albeit understandably, because this only came up yesterday.
Yes, I just in light of the helpful concession, it just seems
Well, on the basis that you'll get the information they want within the 14 days.
yes.
Well, I rather thought at the beginning that we might be able to sort everything out, but we didn't, and we'll have to write a judgment. Fine, that's what we're here for. But the reality is, it does seem to me that the parties should continue to talk. Let me just, can you take us to section 30?
Oh, it's not in. Sorry,
I know it's not there, but it'll be in the white book. It's the Administration of Justice Act, isn't it?
Yes, 1960.
Yeah, I'll check it after.
In volume 2, I imagine.
I apologise, I don't have it. I'm having to log in.
Okay, well, if Mr. Scott can do his best as well, then I'm sure we'll get there. Not sure it is here anyway.
I'm happy to liaise with Mr. Scott and see if we can bottom this point out.
Yeah, well, let's just see if we can find the administration just.
Well, I've got it, yeah.
No, I mean, our powers things, but we do have power. I think properly analysed, what you are asking us to do on the hoof, as it were, and there's no criticism of anyone, because, as I say, these things have come late, and I'm very glad that it looks like you're going to be able to sort things out between you, which is much better than appearing in court. So you are effectively asking us to admit as fresh evidence the letter, and in the light of that, to find that the sentence is manifestly excessive as it now is, as it were, because that's not then purging the contempt, but effectively getting around that issue.
Yes, I think that will have to be
the legal route by which it's done, and then saying that the powers we have under Section 30 are sufficient. In the same way that in the Court of Appeal Criminal Division, if someone is sentenced on a certain basis and then things develop, the court on a principal basis can revisit sentence. Mr. Scott, as that's done on the hoof, is there anything you want to say about that? I will give you both till 4 p.m. tomorrow to liaise with each other, and if you want, submit a joint note if possible, but separate notes if not, limited to 5 pages each, because I don't want your clients to end up paying a great deal more money on these points. But I mean, to say whether that may be a permissible way to deal with that letter in the light of the further points. Is that all right?
My lord, yes, I think that's sensible. Thank you.
Good. Okay, well, thank you all very much indeed for your assistance, and for those sitting behind you.
Oh, sorry. I'm reminded that we think bail might run out.
No, I was going to say bail continue until judgment or further order.
Okay, thank you.
Right. So that's what I'd already said, that it's in some respects academic which way one does it, whether it is a purging or a fresh evidence, or we allow the appeal or dismiss it, whatever. Thank you very much indeed for all the hard work that's gone into this. Thank you for the obvious cooperation that the parties are now displaying, which is a much better way to deal with legal proceedings, as we all know. We'll produce a reserved judgment. When that comes out, the Counsel General in Wales will apply to it. So please don't distribute it other than in accordance with the strict prohibitions, because there's been quite enough contempt of court as it is. Thank you.
What prize has been